our classes, we've been asking right away at the beginning, how many of you understand antitrust and how we got into this mess in the first place? And typically there's, there have been like 180 people in the room, and we've seen 3, 4, 5 hands. So we decided that y'all probably better know what antitrust was so we don't violate it. And one of the reasons is because the settlement only took us to August 17th, right, John?
Yeah, so the settlement only applies. That's some fun feedback. So the settlement only applies really up until August 17th, and anything going forward, that's free territory, unfortunately. So you're not prospectively released from any potential antitrust issues moving forward. Obviously, if you're complying with the terms of the settlement, you would think obviously that you would be good to go, but from a legal liability relief standpoint, that only covers really anything pre-August 17th. So we really do need to have this conversation as realtors about how we move forward and what our best practices are moving forward, so we don't ever end up in a scenario again where we have to be in a large lawsuit or we've got all these practice changes. So we really need to make sure we understand what happened in the past and what should we do in the future so we're not in the same position again. Because I don't know about you, I don't really want to go through all this again. I've been dealing with it for the past 6 months at Davor and as an attorney. So to the extent we can not do that, that would be great.
And just FYI, Sean and I sit on the antitrust compliance committee here at Davor, their task force, I guess we call it. So when he says we've been living through this, we've been living through this. So we hope that this information will really be of benefit to you, and then spread it around because it's that important. All right. So let's play this little video. You get done with it. There you go. This is a video from NAR describing antitrust and what we as realtors need to be paying attention to, and then we'll cover it.
Competition in today's real estate market is vibrant, and not only because of record sales and property appreciation. Today's consumers have extraordinary choice regarding the level of service and price consumers pay for real estate services. And as an underpinning of competition in the United States, the antitrust laws aim to ensure that consumers continue to have optimum choices at optimum prices. This window to the law addresses how the antitrust laws apply to real estate and will help you avoid the perils of anti-competitive behavior, which can lead to federal and state enforcement, criminal fines and imprisonment, and private plaintiffs seeking huge sums of money in damages. First and foremost, real estate professionals should always make business decisions unilaterally and independently. The antitrust laws prohibit agreements between competitors that unreasonably restrain trade, including price fixing and group boycotts. In fact, this type of competition limiting activity is considered so egregious that courts won't consider any justification or defense for the behavior. Any agreement to fix prices is prohibited, and real estate professionals should never agree expressly or implicitly with their competitors about matters such as the commission rate charged to consumers or the cooperative compensation they will offer to MLS participants. Real estate professionals should avoid discussing pricing altogether and should always make these decisions unilaterally and independently. And remember, commissions are always negotiable. Similarly, brokers should never agree with other competitors to refuse to deal or to only deal on certain terms with another competitor or business. Not only could this violate the ethical obligations under Article 1 and 3 of the Realtor Code of Ethics, group boycotts are prohibited by the antitrust laws. To avoid antitrust liability, keep these best practices in mind. Do not agree to fix pricing with competitors, and don't agree with competitors to boycott or refuse to deal with another broker or business. Do not agree with competitors to divide up markets, customers, or practice areas. Market allocation agreements, such as you take the listings on the east side of town and I'll take the listings on the west side, are generally illegal. Brokers may be held liable for the anti-competitive behavior of their salespeople and staff. Implement a written antitrust compliance program and regularly educate salespeople and staff about the antitrust laws. And never contribute to anti-competitive discussions, whether in person or online. If you find yourself in a meeting or conversation where anti-competitive behavior occurs, make your objection clear by leaving the meeting and ask that your objection be recorded in the minutes or documented in a follow-up email. Realtors play a pivotal role in facilitating one of the most important transactions in a consumer's lifetime. And thanks to realtors participating in the MLS, these local broker marketplaces help ensure buyers and sellers have the greatest access, transparency, and choice when it comes to real estate services. For more information about competition in real estate and related resources, check out competition.realtor. Thank you for watching this episode of Window to the Law.
Yeah, we are.
Good job.
Thank you. All right, I'm done for the day. Good luck, everybody.
Okay, so what we have here is our disclaimer. Now, he is an attorney. He is not your attorney, nor is he your company's attorney. So we just need to do a little bit of a disclaimer.
Or my neighbor's attorney.
Or neighbor's attorney, right? All right, so you'll see here. We put this up so that you understand who we are not. This presentation is not a legal lecture about liability, whether you are liability, whether you're liable for an act or omission of an act in a transaction is a highly fact-specific determination that is governed by the federal and state laws. Neither the sponsor nor the instructor are engaged in rendering legal accounting or other professional services. If legal advice or other expert assistance is required, the services of a competent professional specialist should be sought. And this class still focuses on how brokers and agents will effectively address the issues related to potential antitrust violations before they become an antitrust lawsuit. That's the goal. Okay? So we're going to cover the antitrust laws. How many of you ever have studied the antitrust laws? We do. Okay, so everybody says, well, where did this go? Right? So we're not going to do a great big huge history lesson, but you have to know this. In 1890, the Sherman Act came out. It's a one-page act, one-page document that has caused a lot of issues throughout all of the United States and different businesses. In 1914, the Clayton Act came about, and one of the things that it did was amended the Sherman Act, which we'll talk about. Then came the Federal Trade Commission Act, Robertson Act, and the Keller-Coffman Act. So one of the things that we learned about in the Sherman Act and those assumptions is competition, not cartel pricing. Best ensures the quality of product services regardless of any empirical evidence otherwise. So when we keep saying everybody needs to decide their pricing independently, that's what that means. So whatever you decide to charge for listing or for buyer rep, that's an independent decision. All right, the fairness of uniform pricing is not relevant. Consumers will seek lower prices rather than satisfaction of paying inflated prices as everyone else does. So the provisions say no fixed prices. You cannot rate bids, which you don't really engage in. And you cannot engage in any anti-competitive activities, which we're going to talk about. And we've learned that it's enforced by the DOJ, Antitrust Division, who have become our really good friends, right? And now, one of the things that people say, well, I think there's nothing in writing. It doesn't have to be in writing. If a bunch of you sat in this class or you went outside to have a discussion and you violated the antitrust laws, it doesn't have to be in writing. You just did it and somebody overheard it, you're in trouble. So if there's collusion, you cannot justify that agreed upon prices were reasonable or necessary. You cannot justify by ensuring that each party has shared market. So what we're going to talk about is how we got here. So the violations, now you know what NAR paid, right? I mean, millions and millions and millions of dollars. So if we're a corporation, you can go up to 10 million, imprisonment for 3 years, violation of mail or wire fraud, any prosecution within 5 years. So the Clayton Antitrust Act, and this is what I thought was interesting, was it addresses specific practices that the Sherman Antitrust Act forgot to put in or didn't cover. And so what it does is it prohibits appointing the same person to make business decisions for competing corporations. Now think about that. in the real estate industry. Think about some of these people who are in two different corporations. Maybe it's a national franchise and then one locally, and they're making decisions. So that's the act that covers that. So now Sean's going to take you on a trip through Federal Trade Commission and everything fun like that.
I'm gonna stand up. Do you guys need me to use a microphone?
Yes.
Yes, please.
All right, I hate using microphones, but I'll do it anyway. What's that?
I hate not being able to hear.
All right, well, I don't like to live this thing up here. I like to prefer for this. Anyway, so my name is Sean. I'm an attorney here locally. I've seen some of you in other classes. I'm also on the board of directors here at Davor. I'm going to talk a little bit about the background of how we got to where we are in the real estate market. And I'm also going to talk a little bit about antitrust in general, just so we can have that concepts in our head, because we really need to understand these concepts so we understand in the future when we're presented with this situation where we're, wait, I didn't hear about that when Marcy's class. Let me think about that concept. Ah, that makes sense. That's what the type of thing we need to avoid. For example, like at its basic level, antitrust is, let's say all the milk producers in America had an association and they got together and they went to their meetings and they said, well, we're going to charge $10 for a gallon of milk for everybody. Well, then all of the milk in the United States would be set at $10 a gallon, right? And how would the free market, because the United States is based on free market, competitive pricing. Can you do it better than the other person? Can you do it cheaper for the other person? That's really what you're looking at when it comes to anti-competitive or antitrust violations, is a group of people who are ostensibly competitors. In other words, you know, there's Bud Milk and I don't know, there's Fairlife Milk and whatever they may be. They're competitors, but they're making an agreement. Well, we're going to charge one price with respect to. So it can be as simple as the price of milk. That's price fixing, right? So you know, use those concepts when you're thinking. Because I get people that call me all the time and they say, well, can I talk to my competitor about my business practices? The answer is really no, because what you're doing is you're having a discussion with them, an agreement about, well, this is what I'm going to do, and you should do the same thing. So if they call you up, then we're in the same. That's exactly wrong. That's what we can't be doing, and that applies to every industry, not just real estate. It applies to all industries with respect. So just keep those concepts in the back of your mind. If you ever and say, well, yeah, there's right, the hood milk. You know, we can't all agree to charge the same price for something. And so that's where things become problematic. So how is that enforced? It is enforced, as Marcy indicated, through the federal government, through the Federal Trade Commission. You don't see the FTC come in too often. They've been in the news recently because they're trying to ban non-competes and the question of whether they can do that. But you'll see the FTC come in, and obviously since that's involved in trade and commerce, that's where the FTC often will come into play. But in reality, what you're mostly going to see is the DOJ, the Department of Justice. They bring antitrust or anti-competitive matters all the time. Recently, there was a Google antitrust that they brought an action for, were successful against Google. They also get involved in mergers. So I think recently, for example, JetBlue, and I forget if it was Frontier, somebody else wanted to merge. And they said, well, if they merge, is that really going to be courting the market in a certain way? And that's when the DOJ got involved with respect to that. I think they just want Alaskan Airlines and Hawaii Airlines. I think they're going to be okay. I guess they're different markets or whatever it may be. But it's really important. Does this have a laser pointer? Gotta figure out how to do that. Anyway, it's really important because it matters for our purposes today that there's the DOJ matters and then there's civil actions. And people get them confused because they think, well, oh, well, we're all set with the DOJ, for example, right? And well, actually, the DOJ is still out there. I'm going to go through sort of the timeline in that. Some of them are related, but they are not dependent on each other. You can have civil actions and you can have DOJ actions. DOJ is initiated by the government. You have broad investigatory power and scope. It is never nice when the DOJ pops in because they have far more power than a private individual would be to investigate. And then those can be criminal or civil. They can impose fines and they can impose practice changes. So the DOJ can do that. On the right side is you have what are generally handled by plaintiffs' lawyers, by class actions. Those can be antitrust matters that are brought by civil attorneys. I used to be a litigator. I'm not anymore. I've never brought a civil antitrust matter. But that is if you would identify a problem that you see potentially in an area. and you would then look for plaintiffs to bring a lawsuit with respect to that. And that's actually what happened with NAR. That is the matter, that is how NAR's lawsuit was ultimately settled. So on the right side is actually what NAR settled, is a civil lawsuit that was brought by individuals in Missouri, in federal court, as a class action lawsuit. Generally, they're narrowly tailored to specific industry issues, and the real upside for plaintiffs and plaintiffs' attorneys is their treble damages. In other words, if you get a judgment for $1 billion, you actually get $3 billion. Because they say when they wrote these laws, it's so important that we not do price fixing, that you're not only going to get your attorney's fees and all the other, you're actually going to get 3 times what the actual damages are. And they can also issue injunctions, though, which is a bit unusual for a civil case. Usually civil cases are about money. Whenever I was meeting with clients and we would talk about, well, I'd say it's the principle of the matter, right? I really want this to happen. But I always have to remind them in the end, it's really a business decision. You get money, one gets money, but actually in civil lawsuits in antitrust, you can actually get injunctions. And NAR was actually facing the prospect of that, which is part of the reason, ostensibly, that they settled in this case. Okay, well, let's talk about, originally I had me meet again my friend up there, but I took that out because I wasn't sure. But DOJ and history with NAR, actually, and this slide could probably go all the way back to like 1940 something, like we could probably be going all the way back up here. But the DOJ has been investigating, working with, looking at real estate practices for years. I don't know, 80 years now. So this is not a new thing. But I just wanted to bring everybody up to date. So back in 2008, the DOJ and NAR agreed to a settlement practice changes. Doesn't really matter what they are for today's purposes, not really helpful. But they were agreeing to do certain things back in 2008. And then the DOJ was going to actually monitor their progress and what was happening with that settlement. And then in 2020, the DOJ reopened the investigation into NAR. And then in November of 2020, NAR reaches a settlement agreement with the DOJ. That's when you first heard the terms. You cannot advertise that your services are free representing a firing agent. That's actually where that came from, was the potential settlement with the DOJ in November of 2020. I won't get into the politics of it, but you might recognize November of 2020. There was probably something else that was also going on around that time frame. And then interestingly, in July of 2021, the DOJ withdrew from the settlement because they had agreed verbally this is what we were going to do, but it had never been finally approved by the courts, never been finally approved by anybody. 2021, DOJ withdraws from the settlement after NAR had already implemented those practices. So essentially the DOJ pulled the rug out from underneath that settlement that had already been agreed to at that point in time with NAR. And of course, NAR appeals the withdrawal of that settlement and says, wait a minute, you agreed to this, we had it in writing. You may not have signed off on it, but you told us we made practice change, we relied on that. And the DOJ said, sorry, not going to honor that agreement. And the court said, don't have to honor that agreement because it didn't comply with certain pieces. And went all the way up on appeal recently in July of 2024, NAR was still attempting to enforce that settlement because obviously that would have resolved any current issues with the DOJ, because once we would enter a settlement, that's sort of it. And they lost the appeal to the DC Circuit. And as of today, the DOJ continues their investigation into NAR. I'm sure a lot of you have seen Kevin Sears. He's talked about, even at the time of the settlement, he said, this is great, we've got this settlement, but we all have to be concerned about the DOJ because there may be additional enforcement actions or other matters that they're going to rely on. So that is also something that is continuing. So this relates to the DOJ. This is the government action, so to speak. I had those 2 slides up there. Okay, well, the next slide is, if there was no settlement with the DOJ, where did all these practice changes come from? That came from that civil lawsuit on the other side that I was talking about, civil enforcement with respect to antitrust. Because you as an individual privately can then bring a lawsuit against any business, which they did. And this is the Seitzer and Burnett case that was in Missouri. It was filed in 2019 against NAR and other brokerages alleging violations of antitrust laws. In June of 2021, the court granted class action certification. And then I hope, as most of you know, went to trial in October of 2023. The jury was out for 2.5 hours, returned with a verdict of $1.8 billion in favor of the plaintiff, treble damages, as we talked about, $5.4 billion. NAR indicated they would appeal, they did appeal. While that was on appeal, I don't have any insight into it, but NAR decided to settle the case with the plaintiffs, staring at a $5.something billion judgment, as well as potential injunction against them for practice changes. So that settlement is what has been part of our practice changes that we've put into place as of August 17th. Well, we really put them into place as of August 1st. But as of August 17th was the deadline for the implementation of those practice changes. And that was part of the settlement with the plaintiffs in the Seitzer and Burnett lawsuit. And one of the important pieces in this is this actually releases all sellers nationwide. So you cannot ostensibly have a lawsuit on similar grounds in California, Florida, in New Mexico, whatever it may be. So the upside for NAR, for realtors, for brokers, was that this settlement and these practice changes would release any and all sellers that are covered under that settlement agreement throughout the nation. And that was the appealing part, I assume, for NAR, brokers, MLSs. It releases MLSs, it releases brokers, it releases agents as of August 17th. There is one important piece to note, and this relates back to the DOJ. The court, since it is a class action, the court must approve the settlement. Usually as a plaintiff's attorney or a defense attorney, once we enter into settlement, the court doesn't really care. They're like, great, it's off my dock to deal with it. I'm not worried about it anymore. But in this instance, because it is a class action that literally releases people who don't even know about this lawsuit, right? So it literally releases anybody in the United States that doesn't opt out of the lawsuit. So essentially the court sort of sits in judgment. Is this fair for all of the people throughout the land? And that's why we have this final hearing on settlement. So everybody has heard about the preliminary settlement. It's been preliminary approved by the court. And now everybody gets to weigh in on whether this is really a good idea or not. And whether they're going to actually go forward and do this. Because once the judge signs off on this, the language of the settlement is going to release nationwide. And so that's a pretty big power, right? I mean, it is kind of crazy that like some court in Missouri can sit and it can make a decision that's going to affect everybody, and it's also going to release the liability of everybody. I mean, that's a big decision. So November 26th is I would mark that down on your calendar because that's going to be an interesting day. Because our good friend, the DOJ, will come back and they will give what they call a position statement, because they will say, we like this settlement, we don't like this settlement. Judge, here's why we think when you've got it, why you should or shouldn't approve this settlement. I'm going to guess they're going to have something to say about the settlement, because the DOJ doesn't necessarily, at least based on their other positions, agree with everything in the settlement. That doesn't mean that the judge has to listen to them. The judge can do whatever he wants, so long as it's within the bounds of the law. So anyway, it's important to understand, because I get this a lot, well, the DOJ. This is, in reality, the settlement is all about the civil case, and the DOJ is still out there, so there could be some other stuff that we have to look at. Why does the DOJ care about the NAR settlement? They continue to investigate post-NAR settlement, and we'll give a position statement for the final hearing on November 26th. DOJ's position could affect the trial court's decision to accept the settlement. DOJ is not bound by the settlement that only binds individual sellers nationwide that did not opt out, not the federal government. No judge in Missouri is going to bind the federal government, right? And they're just not going to, that doesn't fly. But according to NAR, they have had discussions, they've had sit-down meetings with the DOJ, so hopefully they can come to a resolution. It's important too, because as we talk about antitrust, one of the things that the DOJ is looking is, okay, well, you claim you're going to make all these practice changes as a part of your settlement. Are you actually doing it? Are you taking it seriously, or are you trying to get around it? Are you thinking you're going to be cute and you're going to come up with ridiculous pictures that you're going to put on the MLS? Like, are you actually going to do that? Are your forms going to be appropriate, or are they not going to be appropriate? So it's important to keep all that in mind as we go forward. So, okay. That's my really long form on how we got to where we are. I'm sorry if everybody's heard that before, but I do think it's important because it really is two separate pieces, whether it's government or whether it's civil. As we all know, please everybody tell me you've heard about all the practice changes as of August 17th, please. And if you haven't, please come see Marcy after this. We'll have a discussion. So as everybody knows, we're just gonna go over it one more time. We're gonna eliminate and we're gonna prohibit any requirements of offers of compensation in the MLS between listing brokers or sellers. So in other words, in the past, not now, before you put a property on the MLS, you had to offer some compensation to the buyer broker side. That practice was actually eliminated before the settlement, but just to be clear, that's obviously one of the practice changes, so. There's not even a compensation field in the MLS anymore, so don't do that. It's retained and defined cooperation for MLS participation, so one of the defining terms of cooperation used to be related to compensation. There was something about commissions and cooperation. That's out now. It just says we need to cooperate, we need to provide information, we need to provide access, we need to do the things that we should do under the professionalism that I'm sure Mark Siegel, always talks about, and very important. We're going to continue to do those things. We're just going to leave compensation out of it now. We're still going to cooperate as realtors. We're going to show properties. We're going to do all the things that we should do. That's what we're going to do. This is easy. At least I hope it's easy for everybody at this point. We did have our first time, I think, but don't mention any compensation in the MLS. Don't put it in the confidential remarks. Don't upload a supplement. Don't do anything that could be related to compensation. I promise you it's going to be okay. I promise you it's going to be fine. Just call them up and ask. Just don't do it on the MLS. Just send an email, send a text message, call them up. Don't spend any mental energy trying to come up with a way to make offers of compensation in the MLS. Just call them up and have a conversation or text. All right, we did this. Require the MLS to eliminate all broker compensation fields and compensation information in the MLS. Oh, one of the things people ask me is they say, well, I'm not allowed to talk numbers. So when they call me up and ask me, what do I say? Well, no, that you're not allowed to talk numbers on the MLS, and you're not allowed to talk numbers in a group as we sit here today. But if somebody calls you up and says, Marcy, are you offering compensation on that listing? You can accurately answer that question and disclose to them what they say. Because I have heard people say that, just since I've got you here now, that you don't have to, it's not hide the ball, it's not any of that. Okay. Require the MLS, so we can't provide any data to any third parties where they're going to aggregate our listings and then publish compensation on them. Caveat, of course, is your own brokers can maintain your own listings on your property, on your broker-specific websites with offers of compensation, but we can't link to it in the MLS. Okay, just continue. Same thing. I have heard of people who are using third-party services to aggregate, I guess, compensation. Please speak with your broker. They may have a very different position on that. Remember, your brokers are also on the hook with respect to this, but they're part of the settlement. So if agents are doing things that they shouldn't be doing, you're also putting your brokers at risk. So please make sure that whatever you're doing, it's in compliance with your broker policies. Obviously, it doesn't violate the settlement and it doesn't violate the MLS rules, but they may have stricter requirements. I mean, I've heard some brokers that have stricter requirements because they feel that that's appropriate in this, because that's just from a risk perspective, right? It's all about risk management, like class we took, or we did. All right. No filtering, you can't filter, so you still need to present to your clients any and all listings that might fit their criteria, regardless of any offers of compensations or concession. So you must do that. Filtering, steering is another word for it. You cannot steer your clients towards offers of compensation. If they aren't offering compensation and your buyer wants to see it, that's a discussion between you and your buyer and where you want to be. Remember, you can always ask for potential compensation or concessions in an offer, even if that seller, that specific seller, is not offering it. And I was having a conversation the other night with somebody. I don't know if we were talking about Marcy. Let's say your buyer says to you, I don't want to see anything that's not offering compensation or whatever it might be. And so you have that in your head. And then there's this great property that comes on the market, but you don't show it to them. We all know occasionally people change their mind about their price points or what they're really looking for, and then you don't show it to them. And then later on, they find out you didn't show it to them. You said, well, wait a minute, I still would have wanted to see it. Did you not show it to me because they weren't offering compensation or you were worried about we don't want to be in any of those positions, right? So please make sure you're appropriately sending all those listings to your client. There may be circumstances where they instruct you not to. Make sure you document and file though with respect to that, because you don't want anybody to complain, especially when it comes to compensation. Oh, why, he didn't show that to me because, you know, they weren't offering, compensation, or he didn't like the compensation on that one, so he didn't show that one to me. So I strongly recommend showing all properties, right, Marcy?
Our buyer agreement, did you have in your yes and no for concessions?
It does, the current neighbor buyer broker exclusive agreement does allow the buyer to make an election for concessions, not compensation. Anybody that's talked to me knows that concessions are not compensation. If they don't want to see those properties, please check with your broker. I think it is in everybody's best interest to show all the properties because everything is negotiable, so you never know. And that's the best way to probably work with that. Require MLS breakdown. Okay, this is the other big one. I know it's the other side of it. You have a buyer broker agreement. And part of the reason is also for this is to effectuate some of the other portions of this, is that we don't want a steering. And so if I have an agreement with the buyer and it says I'm going to be paid X, what does it really matter whether or not they're offering compensation on the listing, right? So that should, in theory, level the playing field with respect to showings, because whether I show you this one or that one, I have my buyer broker agreement and I'm going to get paid X. So it really shouldn't matter what they are. Now, as a financial matter, some buyers may say, well, no, I need compensation because of, I don't have closing costs to do that.
Or any written agreements? What? Or any written agreement, doesn't have to be.
I know, and it's important. So I say, unfortunately, because I worked on it, I say buyer broker agreement. It doesn't have to be a buyer broker agreement. It has to be a written agreement with the buyer that complies with the 4 terms of the settlement, that outlines the compensation, has the appropriate disclosures in it. It has to have all of those 4 requirements in your buyer broker agreement. It doesn't have to be called the buyer broker agreement. It can be called the compensation exchange. It can be called the Sean agreement. You know, it can be called whatever agreement you want to call it, as long as it's a written agreement. It has the required terms, and you can readily ascertain what the compensation is due. Right? You can't just leave it open. I know we're going over other classes, but since we're here, we may as well have that conversation. That's like people always ask me, "Ooh, I got you guys here. Do I have to use the NABOR contract or NABOR form since we're in Naples?" The answer is no. You can use any form that you want. You can take the back of that paper, ma'am, write on there all the material terms, submit that, and sign it, and that could be a binding contract. So I want to, since I've got all you here, you don't have to use NABOR forms. Obviously, you want to make sure you're not mixing and matching forms with respect to it. I think you're going to see a lot of brokers that have their own buyer broker agreement, or their compensation agreement that complies with the terms of the, I just don't know what to call it, Marcy. I don't know how to give it a good name. All right, whatever this buyer compensation agreement is that complies with the terms of the settlement. So, you're going to see a lot of that, and, so check with your broker and make sure you have all that paperwork. Okay. All right, well, I can turn it back over to Marcy. That was your legal update, so thank you.
Give it a round of applause. Why he does legal update. All right, so the next thing we're going to talk about are what are some of the things that we run into here. All right, so as a real estate professional, what are some of the common things that could happen to you that would violate antitrust? Well, the first one would be price fixing. That's the first one, which we're going to talk about them all individually. But price fixing is the one that probably shows up the most. Okay. The next one is time arrangements. And I asked in class the other day how many of you knew what time arrangements were, and nobody raised their hand. And that's the mystery one. And then we have group boycotts, which goes on more than you would know. And then what's market allocation? So let's start with price fixing. It's an agreement amongst a competitor to raise, fix, or otherwise maintain the price at which their goods and services are sold. So you talked about milk, talked about the price of milk. And one of the things that you also mentioned being, what happens if we all of us attorneys send a letter out and said, this is how much we're going to charge for title work? That kind of thing. It's not necessary that the competitor disagrees to change exactly the same price, or that every competitor in a given industry joins the conspiracy. Price fixing can take many forms, and any agreement that restricts price competition violates the law. Now then, the lawsuit said, we fix prices. because there seemed to be the same number showing up. Time and time and time again. Right? Today I was on the phone with an attorney down in Mississippi. And I'm writing broker policy manuals for their company, 17 different states are licensed in. Anyway, she had changed the document from what it was before. And I said, why did you put in the document on the earnest money that there's a blank and then a percentage? And she said, well, I'll fill that in. And I said, that's fine, but why did you put that in there? And she said, well, my agents tell me that's a standard amount. Now, this is an attorney. One thing that should never come out of an attorney's mouth is the word standard or out of our mouth. And I said, where did you get that idea? She said, no, all of our salespeople say that. I said, no, the earnest money amount is the amount that the buyer offers and the seller accepts. Whatever that is, there is no standard amount. And she said, oh, I learned something today. I said, well, good. All right, identical prices may indicate a price fixing conspiracy, especially when the prices stay identical for long periods of time. And if you go back 50 years ago when I got in this business, some of those prices looked the exact same. Prices previously were different. Prices increases do not appear to be supported by increased costs. And a lot of people are saying, wait a minute, what are you doing to make your income so much more substantial than what it was? Show me what it is you're doing. And then discounts are eliminated, especially in a market where discounts historically were given. So that's when they're coming up and saying that's price fixing. So time is one of my favorite ones to talk about because very few people understand time. So time arrangements are when you require two distinct products or services as a condition of a sale. In other words, you know that song, you can't have one without the other? That's what this is. So the first one that comes to mind is tying two transactions together. I gave this as an example in class the other day. So I own a management company, property management company. And in my property management agreement, I have written in there that if you decide to sell this at any point in time, it has to be listed by me. I have tied two transactions together. Okay? And where that would fit in with you might be, how many of you lease like properties during the season? Go find rentals, right? Well, they come down here and they rent for what? A couple of years, and then they. So if you try to tie your leasing agreement to a future buyer rep agreement to purchase, can't do that. That's time. So you can always say, I hope you remember who I am, and when you decide to buy, then you give me a call. The other way is, I said, the management and sale agreement. Now then, there will be a lot of people who say, I see this all the time, right? You want to comment on it?
Well, I mean, I guess I will just briefly, because I know, I'm sure people in here have sold new construction and there's often incentives offered to use, or that's different though, right? Because you're not required to use their services to get X. They're offering you an incentive to do X, and then you get a free kitchen upgrade or something, you know, whatever it is, right? And of course, me as an attorney, when they say, well, I should use you or should I use theirs? You know, well, I can't offer you a free kitchen, so I don't know what to tell you. But so there is a difference though, because you will see some of that there. What Marcy's talking about is a straight, well, unless you use our mortgage lender, we're not selling you this home. That's very different than if you use our mortgage lender, we will incentivize you with, you know, I don't know, a brand upgrade or whatever it may be. As you can tell, I've seen those before. So yeah, so keep that in mind. Incentives are very different though than necessarily time, and that's perfectly acceptable and legal. That, by the way, that's what you see in anti-coercion in your mortgage packages. You'll see a disclosure for an anti-coercion related to insurance. That's the type of thing where they're saying, oh, you didn't have to use, we didn't require you, Mr. Leonard didn't require you to use this insurance company. That's what that anti-coercion statement you'll see in the loan packages are. So anyway, that's why.
I used to teach in Texas a lot, and down in Austin and Houston, and those brand new developments down there that the builders building, you don't have an option. You will use their title company, and you will use their lender if you need a lender in order to buy their, because that's where the profit is in that title company and in the mortgage company. So it differs from city to city. And then I told you about the lease buyer agreement. So those are tying agreements. Does it make sense to you now? We're tying two transactions together in some way where you're going to benefit because of the tie. Now, I had hoped that I would have by now a video called What Happened to Harry? But NAR promised it to me, but we still don't have it. So sometime if I ever get it, I will share it with you. So this is the Greater El Paso Board of Realtors. So I'm going to tell you a story. Back in 1985, I happened to be president of my local association of realtors up in Iowa. And it came to us and said, we need to get all new liability insurance for the board of directors. What did you do? He said, well, you didn't do anything, but this El Paso Board of Realtors really screwed up. So now we have to increase our liability insurance. So they showed us this What Happened to Harry video. And you would have gotten a charge out of it because everybody in the video was smoking. It was good. So what happened was in El Paso, they had a pretty, all the brokers there had a really good command of the brokerage business, and they all used a certain fixed commission. By the way, when I started in the real estate business back in the olden days, the commission amount was pre-printed in the form by the Board of Realtors. We've come a long way. So anyway, they had a little bit of business going. And then Help You Sell decided to come to town. Have you ever heard of Help You Sell? Yes. Okay. So they're a flat fee brokerage company. And what you do is you list your house with them and they charge you a minimum commission and you show the house yourself and you entertain everything. And all they do is put it out on the MLS and market it for you. And you do all your own advertising or whatever, however the method of services that you pick works. So Help You Sell started to make some really good inroads, right? And so they all of a sudden noticed that nobody was showing their listings. And they started asking around and planted a couple of people here and there. And what was happening was people said, well, we were told not to show your listings because you're not compensating us. We want to be compensated. And so we're not going to show your listing. We are boycotting. We are boycotting you. In great big huge terms. So that didn't go over very well. So they called our friends at the DOJ and said, maybe you want to come down and visit. And the film is just funny as all get out. Because the DOJ came down, had investigators planted in the kitchen with a little camera between the blinds, looking into the dining room. And then he hired a seller. A seller. And so the seller wanted to list his house, supposedly. And he called every single real estate company in El Paso. But he wanted only the brokers. He only wanted to work with the broker owners. Who showed up in their Gold Center 21 jacket, in their Remax jacket, wearing all these guys, all dressed to the nines, to talk to the seller about listing their house. And when it got to a certain point, they said to the seller, are you ready to list? And the seller said, well, I have a question. What about this company called Help You Sell? And he said, well, if you list with Help You Sell, nobody will show your house. We boycott them because they don't pay us the commission. And it's on tape over and over and over again. So that was just the beginning. So then the president of the Board of Realtors called a special meeting of all the brokers. and said, something doesn't smell right. Are we all in agreement we're boycotting that company? And they had a plant in there, and they had that on film. And it went on and on and on and on and on. It shows business meetings, it shows a barbecue in the backyard, all talking about, don't ever go, we all still charge this amount, right? So the long and short of that was that the DOJ took them to court. And it's Park versus El Paso Association of Realtors. And that's why we are really careful about our E&O insurance, because they stuck some of those folks in jail, and they penalized and fined for it much money. So that was the greatest example of boycotting that I could come up with, because I personally lived through that whole thing. And it was one of those things where I thought about, you know what, I have seen that happen in other situations. There are a lot of examples of that around. So just be careful. When you say, I'm not going to show those houses because. The other case is just a really easy one. Some of the stuff we're going through right now. There was a case in Ohio where I have told many people, I'm reliving my life. I went through all this 30 years ago when the buyer agency first came about, remember? And I said, when we first brought buyer agency out in the mid-90s, and all of the real estate companies were working with sub-agents only. That's all they were working with. And so as the companies started developing buyer agency programs and company policies and said that they were only going to represent buyers, all those companies who were only working with sub-agents refused to let them show their listings because they wouldn't compensate a buyer's agent. They only compensated a sub-agent. So they were boycotting buyers. And that became a really famous piece, Smith versus Sprague, if you want to look it up. So anyway, those are the two examples of boycott. Now, I never dreamed that, again, this full circle. I joined my Iowa City Board of Realtors in 1973. Long time ago. And when you joined the Board of Realtors back then, you got to meet in front of men in suits. There wasn't a woman around. Anyway, these men in suits would ask you questions like, I see you have children. Questions that aren't legal today, by the way. Yes, I have two. What are their ages? Now, when you're out showing houses, who will be watching the children? What are you doing with the children? Okay. What did your husband do? He said, my husband's a student at the dental school. So he's not home to watch. I mean, it went on and on and on. And he said, well, where do you hope to get your book of business? And I said, well, I'm the president of the Delta Six Dental Wives Association. So I'm thinking that, I see all the dental students coming in and they're buying houses. It's a good market for me. And they stopped and looked at me and said, oh no, that's Mary Irby's market. You can't do that. Mary Irby's husband was a professor at the dental school. It made it very clear to me I was not to near the dental school to give her leads. Now you all know me pretty well by now. How'd that work? Not well. So I took Mary Irby out for coffee and we said, honey, I'm getting up in age. It's fine, just go ahead, but nice of them to try to protect me. But that was a boycott. I mean, that was, basically saying you can't do that. And so was market allocation. And when you think, well, that would never happen here because it used to happen all over, remember? It happened a lot, 10, 20 years ago. And say, no, the vineyards is mine, you can have, rural law, all those, right? So I got a call last year from a realtor friend of mine who said he was helping a new agent who lived in a community here and she got the listing. And she was very excited about it until somebody from her community who was also a real estate agent came to her door and told her she was not allowed to take listings in that community, that he was the person who was the realtor for that community. A year ago, here. So allocation is one of those things you don't want to get in the middle of. You don't want to be involved in that. So be careful of it, and if you hear about it, let us all know. We'll take care of it. So here's how you file the complaints. It's in your handout. When I used to teach antitrust, it was the first slide. And I just said, write this down now, because it's going to come to mind. Something's going to come to mind to you. And we all go to Washington DC and we need to lobby our legislators. And as we tried to do down the street a couple of years ago, I went, oh my God, there's a Federal Trade Commission building. So we took a picture of it and I used to post it all the time. This is where you're going to take the case to. So that's where we need to send the complaints to regarding competitors, consumers, and the Department of Justice. So what we've learned is there has to be free enterprise. There has to be competitive bidding. And competitors must set prices independently. And that's why we keep saying to you, quit saying we all charge this or this is what I charge. And the other thing I want to make clear is I heard somebody say, well, I'm just going to send out a letter that says this is what I'm going to pay to everybody. And I said, that's not setting prices independently. It's this, people need to make up their mind what they want. And then the Sherman Act, of course, guides us. And then next comes the Code of Ethics. So in your handout, you've got this pricing policy. Things that you should never say. So this is the rate every firm charges. I'd like to lower the commission, but no one else in the MLS will show your house unless the commission is this. And I'm fearful that we're going to start hearing stuff like that. Because it comes up in conversations around here. Don't. I have to charge you this rate because this is the rate the Board of Realtors set for all real estate agents. You know that's not true here, but it wasn't my time. Before you decide to list with XYZ Realty, you should know that because they are discount brokers, members of the association will treat their listings. And that was the El Paso. Okay? So then on the other side, you've got all the things that you can say, the things that you choose to say. Get rid of it. I have marketing programs, get results. Let me explain my 60-day program. Our company has been in the business for X number of years, and we have clients with the highest professionalism. We choose to charge this amount. Our clients have chosen to pay this amount because the service is provided. Yes, our company charges a commission of A. The company, too, charges a commission of B. But at the same time, what we should be comparing, not the rates, but compare the services. And then I appreciate your comments. My interest is in helping you meet your goals by giving you the best price in the quickest amount of time and with the least amount of problems. Please let me know how I can show you how to do that. Code of Ethics is very clear. You don't trash anybody, and you can't talk bad about your competitor. You can look it up. It's Article 15. And so when you go on a listing appointment, you may as well say, well, so-and-so will do it for this amount. Then you just have to say, my commission is, I have selected my commission because of the services I offer. And I'm happy to talk to you about my services, but I can't talk to you about anybody else's services or about anybody else's charges, period. I'm proud of my company's reputation for professionalism and getting things done. Let me show you some of our sales or whatever statistics you want to do. So that's in your handout. It's all printed out in it if you want to see it. So now let's talk about the code of ethics. One of the things I think is interesting is that some people say the code, our code for realtors, has also been kind of used as a benchmark for other people that are in the real estate industry. So when we look at the code of ethics and what it covers regarding this type of stuff, we have to, in Article 1, promote the best interest of our clients, right? So everything that you do, all of the first part of working with customers and clients, all of that has to do with how we promote the best interest of our sellers and of our buyers. Next, we have to cooperate with other brokers. Now, if you read through Article 3 is all about working in cooperation with other brokers. And what it's very clear on is it says we agree that we will cooperate, which does not necessarily mean compensate. So there will be some changes coming up, probably when we go to the National Association meetings in November. the professional standards committee is going to have to look at some of the articles in the code and make some possible changes to them. Then, when it comes to standard practice 3.4, we have to disclose if we have a variable or a dual rate commission. We'll see how that pans out, whether they're going to be keeping that in there or not, since we don't have compensation offered through the others. So Article 15, as I said, is no disparaging remarks about your fellow competitor. Article 16 permits aggressive or innovative business practices. Talks about how we can advertise what we've done. I just always talk about the fact that if you're going to compare yourself to others, be careful about that. So the example we used in the class was, we could be having right now sellers who are anxious about getting their household because it's been on the market for a long time, right? And the listing is going to end next week. And they haven't been really happy with your services. And they want to start looking for a different broker. They can call any of you and say, I'd like to talk to you about listing my home when it expires next week. Can you go? Yes, because they called you. You can't call them. So you can call, you can go over there. You can talk about your business plan. You can talk about the compensation that you'd like to earn. You can talk about everything that you do for them. And you don't say one thing bad about their listing agent. You can talk about the market. You can do any of that. And if they're pleased with you, you actually can sign a listing agreement that day that begins the day after their listing expires. But only if they call you. Same thing with buyer brokerage agreements, by the way. And then 16.6, may talk with a client under contract. That's going to goes with that. And when we deal with those kinds of things, we get nervous about it. Because if they've already signed the contract with somebody else, it's not going to interrupt that. That would be bad. So what we have found out is that people who violate these terms are not bad people. They're not bad. They're not criminals, and they're not ignorant. They just use poor judgment, right? They let their mouth kind of guide them along the way. So that's one of the things that we always think about, is that we all make mistakes. Let me just tell you, after all these years I've been in this business, I have seen tons of them when it comes to antitrust. And it's not because they meant wrong, it's just they didn't know better. And so that's why we decided to do this class, so that you would know the difference, and when you hear it, you would know it. When we're in a room like this, remember how we always say now, no numbers, right? No numbers. And that means any commission numbers. We're not talking about the price of house, we're talking about your commission numbers. We tell you to use X% or Y%. So if somebody in the room was starting a conversation and was using all sorts of compensation numbers, what would happen? Well, people who know, because back in my day, they said, stand up and do something about it. So here's what you do. If you hear a conspiracy going on, like we're all going to charge this, we're all going to do it this way. And I just want you to think about it. Right now, we're in a time where people could start doing that, right? So if you hear conspiracies starting, you only have one option: object out loud and be noticed that you really yelled out loud, and then leave, document, and disclose it. Okay? So that's one of the things that you really have to pay attention to. And then your brokers really have to train. I'm afraid to ask, how many of your brokers have been doing anything about training on antitrust? Yay! Yay, yay, yay. That's good, because it's essential to have that there. All right, so we tried to show that other video that's underneath.
All right, friends, this has been a wonderful evening. Great steaks and, even better wine. Right? But now I'd like to get down to a little business. And most of you I've known a long time. Scott, our kids played ball together. George, we played tennis together. I consider each of you family. Even you, Carol. Even though we're competitors, we've been through good and bad times together. Lately, it's been harder to make a profit than any of us have seen in years. I know I could stand to see more cash coming in the front door. So, next week, I'm raising my commission rate to 7%. Just wanted you to know. Obviously, what you decide to do is entirely up to you.
Believe it or not, that was based on a true story. In the 1970s, a group of real estate competitors were convicted of fixing prices on their commissions while they enjoyed dinner at a fancy country club. And the convictions were upheld on appeal. Antitrust laws haven't changed much since the 70s. In fact, they haven't changed much in over 100 years. But the ways that real estate professionals can get into antitrust trouble have changed. So, welcome to Antitrust 101 for real estate professionals. Let's start at the beginning. What is antitrust law? Well, the heart and soul of antitrust law is the Sherman Act of 1890. And while antitrust law is commonly associated with the prevention of monopolies, it also applies to individual agreements to restrain trade. In other words, an antitrust violation occurs when there is an agreement, an understanding, or conspiracy among competitors that unreasonably restrains competition. In real estate, price fixing and group boycotts are the two most common antitrust violations. For instance, our host at the club wasn't just speaking about his own business. He was encouraging his competitors to follow his lead when he announced that he was raising his commission to 7%. He didn't have to directly say that, although that's what he implied. And his guests didn't have to expressly agree to charge the same commission. But when they did, they had formed an agreement that broke the law. Price fixing is always illegal. It's considered a per se offense, and that means there are no exceptions or extenuating circumstances that will excuse an antitrust violation. And the penalties can be stiff, triple damages, even criminal liability, to name two. But don't worry. We're going to cover what you need to know to keep yourself from accidentally falling into that trap. Now, generally, price fixing isn't accomplished by a written agreement. Who's naive enough to write down something that's illegal? Most price fixing violations are unwritten or verbal agreements. And agreements with competitors on other business practices like these are also illegal. Listing properties only on the same terms and conditions, representing a buyer only on the same terms and conditions, offering the same co-op compensation through the MLS, only offering certain types of listing agreements. Often discussions on these subjects are implied and take place in the most innocuous circumstances, over coffee, on the golf course, even on vacation, at a ball game. To avoid getting into trouble, remember, appearances count. Make sure that what you say to a competitor is exactly what you mean. Don't make statements that could be considered an invitation to fix prices or engage in other questionable activity. Just make your message clear. Okay, let's do a quick little self-test. You belong to the North Shore Swells Club, by invitation only. You all sell million-dollar homes, and once a month you all meet to discuss how to market them better. Can the members of that group agree to offer each other a higher commission split than they offer to other brokers? No, that would be price fixing. Consider disbanding or at least dropping out of the group. All right. At a meeting, you hear two competitors agree to fix commissions. So what plan of action would keep you out of trouble? A, stay quiet and don't contribute to the discussion. B, tell the group that it sounds like a decent idea, but don't say anything else. C, make it clear to the group that you don't want to be associated with their plan and then leave the meeting. D, all of the above. The only correct answer is C. Even if you stay silent, you could still be accused of joining the conspiracy. Silence may not be a sufficient defense. And you can avoid unintentionally being part of an illegal conspiracy by openly stating that you refuse to be associated with it. Or even better, be careful to avoid these types of discussions at all.
Nice putt. So, what are your people doing about that thing we talked about?
What thing? You mean the thing with the web ads or that new broker?
The thing with the website. They're totally gouging us on those ad rates.
Yeah, we won't be using them anymore. Everybody's on board at my firm.
Great, mine too.
Yeah, good luck staying in business without our ad revenue.
Exactly. They should be grateful that we even advertise with them at all, but not for long. So, what's the deal with this new broker that you mentioned?
You know, they're the new discount brokerage.
Oh, yeah. They're offering like next to nothing for co-op commissions on the MLS. It's so annoying.
Ugh. What do we do? I hate working with them.
Well, you didn't hear me say this, but it's simple. We're not working with them anymore. You should think about doing the same thing.
Huh.
I mean, just think what would happen if no one did.
That's not a bad idea. I'll make sure we're in too.
Just make sure it stays between us.
Relax. How will anyone know?
These days, the most common potential antitrust violations seem to involve group boycotts. I'm sure you realize if a group of agents or brokers collectively try to put another agent or broker out of business, that would be considered an illegal restraint of trade. I know you would never do anything like that, but isn't that what you're doing when you casually say to a colleague something like, "I don't think we should work with that new broker"? Without even thinking, you're now on your way to a group boycott. And this is also true if you agree with other competing firms to do any of the following: not cooperate with a particular broker, not show a certain broker's listings, not advertise in certain media, and not use particular suppliers or vendors. The targets of these boycotts are often competitors who offer new business models. They could also be vendors or suppliers. And obviously, no one has to work with someone they don't like, as long as that decision is made independently. But encouraging your competitors to go along with your decision to not work with that new guy in town can get you in trouble. And the same goes for suppliers and vendors that you think charge too much or you don't like for other reasons. Don't give them your business if that's your preference. That's fine. But don't ask or encourage your competitors to do the same. And under no circumstances should you say to your competitors anything like, "Let's do something to make these guys lower their prices." Okay, time for a couple more quick questions. If a multiple listings service creates its own real estate listing website, newspaper, or magazine for its participants to publish their listings, this could be considered an antitrust violation. True or false? False. Offering alternative ways to advertise their listings is a completely appropriate way for an MLS to serve its members. There just can't be an agreement among the participants to advertise only in the MLS's paper or on its website, and not to advertise elsewhere. Next, a group boycott is allowed under the following conditions. A, the boycotted firm is not a member of NAR. B, the boycotted firm advertises its flat rate commission structure. C, everyone agrees the boycotted firm is too aggressive or unprofessional. Or D, none of the above. The answer, of course, is D, none of the above. There are no conditions under which a group may agree to not do business with another firm under antitrust law. Don't even think about it.
Beverly, go to the association's Facebook page. You are not going to believe what's going on. There's a post about that referral company that's trying to join the MLS, and people are getting really worked up. Yeah. Max just posted that he is definitely not going to cooperate with them. And he's got 45 likes already. Call me back later. Let's talk about how to handle this. Great idea Max. I've been telling clients that it doesn't seem like they actually take any listings. So why would someone want to work with them? I don't think they have any idea how to market property. Who knows? But I wouldn't be surprised.
There are lots of ways to get in trouble on social media, and there's lots of social media where it can happen. LinkedIn, Facebook, Twitter, blogs, not to mention texting on your smartphone and answering your email. The possibilities for unintentional antitrust violations go on and on. You don't need illegal intent to say something that's against the law, or something that someone will later claim was against the law. So be careful. Always remember that what you say in cyberspace stays in cyberspace forever. When it comes to avoiding antitrust claims based on your comments about competitors, your mom had some good advice to follow. If you don't have something nice to say, don't say anything at all. Here are some more important points. Don't answer email or make comments on websites that disparage other companies or competitors. And don't get into discussions in forums that are disrespectful to other firms or people. Having said that, everyone falls off the wagon from time to time, and maybe you didn't even say something nasty about someone, but you took the easy way out to explain your commission rate to a potential client and said something like, "It's the rate we all charge." Your statement makes it sound like everyone has agreed to charge that commission rate, and that's not legal. And maybe instead you said something like, "The association has a rule about our commission rates." The truth is, no association with an ounce of sense would adopt a rule like that. But don't panic. Follow up with that potential client to clarify your mistake after you talk to your firm's attorney. Okay, one last quiz question. Private communications between friends can't be antitrust violations because they are difficult to prove. True or false? It's definitely false. Even if it is difficult to prove, a conversation that results in an agreement to limit competition is always illegal. And what you think might be a private conversation or comment probably isn't as private as you think. Your best option is just to not make troublesome comments. Always assume your words can be heard or read by someone else.
So while the market is challenging, I'm hoping that we can all have a better quarter coming up. All right, guys? I know we can do it. All right, moving on to the next item on the agenda. Okay, I wanted to say a few words about Big City Realty and the change to their pricing structure. Now, speaking strictly for myself, I'm not pleased at all. I mean, it's tough enough in this market trying to make a living without Big City. But after speaking with several of you privately, I think we need to go further and really show Big City that their structure isn't going to work. And until they make changes to it, they're on their own, completely on their own, if you get my drift. Now, obviously, we can be a lot more effective if we can...
Oh, wow, look at the time. Is it 2:18 already? I have an important call scheduled for now. I'm so sorry, I really need to go. Donna, please make sure you note in the minutes that I left and was not present for this discussion. If it continues after I leave, which it probably shouldn't. That's Tim Evans, E-V-A-N-S. Don't forget the S. Okay, I'm out of here.
Here's a few more thoughts about participating in association meetings with competitors. First, there should always be an agenda for the meeting with specific topics. The invitation should identify the people who have been invited to attend, and that should include everyone in the association who might be interested, not just the popular kids or some other select group. The agenda should be provided ahead of time and spell out exactly what is going to be discussed. And when you get there, be sure someone is taking minutes And the minutes should be on stationery that has the association's name on it, not on someone's business letterhead. And after all that, if it turns out that the group still discusses boycotts, price fixing, or other questionable activity, get up and get out of there, like our buddy Tim Evans. Do not pass go, do not collect $200. And when you leave the meeting, make sure that the person taking minutes notes the time you left and the correct spelling of your name. Then be sure to tell your bosses what happened. Which brings me to my final thoughts for protecting yourself. Be aware. Make sure that you and others in your firm don't do anything that seems like an anti-competitive agreement. Don't participate in a discussion with competitors that involves how you intend to do business with other competitors, consumers, or service providers. If someone invites you to join them in a boycott or price-fixing arrangement, walk away, far away, and contact your attorney to find out what to do to protect yourself from any claims that you participated in an unlawful agreement. The Sherman Act has been around for over 125 years, but there are always new ways of doing business and new applications of the antitrust law in our constantly changing real estate profession. So stay educated. See you next time.
So that's how we introduce that to all our members that come into the board. That's under very Tuesday. So we are down to, if you have your questions written down, if you have any, we will have Tina pick them up and bring them on. Let's see if we can help you in any way.
Just want to give a couple of perspectives too on that video. I think in reality, handle your own business. Don't worry about what everybody else is doing. Focus on your business, your services, what you're going to offer, not what somebody else is or isn't doing. I think really that's what a lot of, at least that video was talking about. Spend more time on your stuff, not on talking about other people's stuff. I'm a New England Patriots fan, and Bill Belichick always talked about his team and what his team was doing, and refused to talk about what the other team was doing, right? Because let's spend the energy on our team, our stuff, not what somebody else is or isn't doing. And as a lawyer, I really want to drive this point home. Never put something in writing that you would not be comfortable reading out loud in court, right? One of my touchstones with my clients is always like, well, like, should I send this email? It's like, I don't know. Would you be comfortable getting on the stand and repeating that for the jury? Are you comfortable standing behind those words someday where that will be, read out and you'll have to sit there and go, oh yeah, I did say that, right? Because it's really hard to disavow your own emails or text messages. So be very careful about what's put in writing and be really sure you would be comfortable telling a jury that, yeah, I did actually say that. That I did write that email. So just keep that in mind. So.
And talking about commissions between the listing agent and the buyer's agents and the things that they can say to go wrong.
I guess in this world of settlement, I would just say that make sure that if you're offering commissions from a seller, from a listing agent, that's agreed to in writing prior to. That's one of the touchstones of the settlement agreement is that the seller must have agreed in writing any offers of commission. You cannot just off the top of your head decide you're going to offer something to a buyer's broker. That the seller has to have previously authorized that in writing in a listing agreement or amendment to that listing agreement. So you can't just come up with your own stuff. And so once again, I don't really think there probably should be too much conversation because you have your buyer broker agreement and your buyer broker agreement has whatever your compensation is with respect to it. So in many ways, there really shouldn't be too much conversation other than is the listing agent or is the seller offering concessions or cooperating compensation? Okay, thanks. And then you have your own buyer broker agreement. And just keep in mind, of course, your buyer broker agreement is limited to the amount of there. You cannot keep any so-called, if they're offering more, then you can't keep that. But on the other side, your buyer is required to, to pay whatever that is, even if the seller isn't offering compensation. So just keep that in mind. There probably really shouldn't be very many conversations. You can disclose the amount. Like I said, people say, oh, they won't tell me because they're not allowed to say that word or whatever the words may be, but that's not true on a specific listing, right? All All right, we got some questions. Let's see how we did.
How much money did our victims receive?
So the first question was, what did our victims receive? I assume this relates to the NAR settlement, and I believe the total payment is going to be for $418 million from NAR. I believe their other defendant brokerages also paid some amount, 70 million, 80 million. I think the total recovery is somewhere around $600 million, but remember that's split among any and all sellers in the United States from the essentially 5 years prior to the time of the lawsuit. And so it's going to be a pretty minimal, just like any other time when we make a class action claim. And it's like, oh, I got $2, great. It'll probably be more than that. I think the lawyers filed for their fees. I believe they believe they're entitled to $139 million based on their filings. It might be. I thought it was 139 based on hourly rates.
33%.
Yeah.
And then they figured that the sellers would each get somewhere around 30.
Yeah.
$30.
And then let's see here, what practice changes, NAR making 2021. I think that mostly related to the, as I indicated, that you could not say that services were free because some buyers agents were representing that their services were free. And that was misleading, at least in the DOJ's opinion, that because actually they weren't free, they were being paid by a seller, so they weren't actually free. And so people who were advertising, oh, free services, that wasn't actually true. And so that was one of the pieces that the DOJ really wanted to emphasize. And that's what the settlement kind of would have, that's what it would have been. But then after they withdrew their terms of the settlement, obviously more has happened and this lawsuit, the civil lawsuit proceeded, which, you know, yeah. So hopefully that answers that question. Oh. Okay, well, I'll be careful on this one. This one asked me, can you explain the reasoning behind the class action lawsuits versus NAR alleging antitrust violations? What specifically was used as examples? This was a claim that because MLS policy required an offer of compensation in the MLS, that it was requiring that all listings were then had to have an offer of compensation to a cooperating broker, which then raised the price for sellers because sellers maybe not necessarily have to make an offer of compensation. So the allegations were that by MLS rules requiring, because you had to put your listings in the MLS and you had to make it, to put it in the MLS, you had to make an offer of compensation to a cooperating broker for at least 1 penny, at least at that time, that was their position, that was anti-competitive. And unfortunately, the judge ruled that was a per se violation, which meant that NAR couldn't provide evidence to show why that was actually a good business practice that protected consumers. And so as a result, there was no ability for NAR essentially to put on any defense with respect to that practice. Now, NAR had subsequently revised the guidance that a penny was the least amount and that it was, they allowed for 0. And then that was adopted prior to the case going to trial, but still went to trial. So that was the basis for it. And that was something that the judge found that it was a per se violation. So it really wasn't too much for the jury to determine. And that's why it was only a 2.5 hour deliberation for $1.8 billion. I've seen the jury verdict form. It's sort of a through the looking glass moment when you see a jury verdict form and it's like signed by 7 people and it says $1.8 billion on it. And that one piece of paper has such a tremendous effect on the industry. It's very ordinary acts, or what appears to be ordinary acts, have tremendous implications for everybody, frankly.
Ordinary acts that went on for a long time.
Yeah. Okay. Buyer's class action. So there is still a buyer's class action lawsuit pending, and the question is, I believe it's the Morel lawsuit, and that is one where buyers have alleged that it was raising prices for them indirectly, and most legal scholars, I'm not a legal scholar on antitrust, think that that's a much more difficult argument to make because it's an indirect raising of costs for a buyer. In other words, that because of the requirement to offer compensation in that, but from a seller to a buyer, that raised the price that the buyer ultimately had to pay. I think most people think that that's probably not going to go anywhere, but that is still pending. So there is a buyer's class action lawsuit. The settlement does not necessarily preclude that from proceeding, although there will be some legal questions about that by far smarter people than me, so.
All right, over.
Okay. So this question says, the customer likes 2 condos that are identical in price, size, etc. They ask me for my opinion. Can I give them my advice? I know about the commission from the sellers for each of those condos. And I think Marcy needs to probably weigh in on this too, but my opinion is, of course, that's what we do. We give opinions about the condos and maybe there's a better view, maybe it's got a better parking spot, whatever that may be, but be transparent about whatever is being offered for compensation, if any, with respect to the property, because that way your buyer has all the information, because maybe for them, one is offering and one is not, which means that it's going to cost actually more in the end from a closing cost perspective versus the other one. That's a financial, and they go, oh, I'd rather choose the one that, offers compensation because that's going to reduce my closing costs. And that's fine as long as you have been transparent with a buyer so that they understand what the options are, because it's all about options for a customer or client, depending on your agency relationship, but a customer, so that they can make those informed choices. Don't hide the ball, because you never want to have that conversation later, like, well, if I'd known that would have changed, my opinion, or I may have thought differently. Just be transparent. You can never get in trouble by being transparent. I promise you. Like, you should always, I use this example, I used it last time. When people ask me about, well, should I disclose this to a potential buyer? And I'm like, well, if you have to call the attorney and ask whether you need to disclose it, you need to disclose it, because there's no point in staying up at night going, oh, geez, shouldn't I have, but now what if happens? There's a problem like that. Please don't do that. It's not worth it. Just disclose it. It'll be much better for everybody involved in the transaction. So just be transparent about whatever the compensation is being offered. They're making choices between those 2 properties.
And remember, our buyer rep agreement says that you can, if you're using a buyer rep agreement, that you can show multiple buyers the exact same property. And that's been there for ages and ages and ages. But the question always comes up, do I have to disclose? And my answer has always been, you should tell people that you are showing this as well to another buyer. You don't have to say that they're interested. You're showing, I was here showing this last week to another buyer, or I was here yesterday showing this to another buyer, so that they know that that's going on. And we always teach you to not so much make comments, but to ask questions. Why do you think this condo would be better than the other condo? It's time to investigate, not to proliferate. That makes sense?
And just make sure if you're saying things like, I showed this condo last week with somebody, that you actually did show the condo last week with somebody, or, like, we already have multiple, make sure you do, because, we don't want to be in a position where we're, people are just puffing and being untrue. So, yeah.
And as John said earlier, we've been faced with lawsuits from the DOJ since the beginning of time. And one of the ones that I was involved in 2008, just as an example of this, there was a point in time when real estate companies were going to have what they call virtual office websites. And so as those virtual office websites started to grow, what they were doing was getting agency agreements signed on the website. So they were signing up buyers just by saying, if you want to look at properties, you've got to check here, and you're represented now. That did not go over well with a lot of real estate companies, and they reported it to the DOJ. So that was the very, very, very first great big huge lawsuit that we had regarding MLSs and that type of thing in 2008. So they've been after us for a long time.
Yeah, I mean, probably, but that's also their role. I mean, I'm not to carry their water here, but that's what they do, right? They're here to ensure that there's a free market. People aren't being taken advantage of. I mean, that's just part of it. And so I would expect that the DOJ will continue to look at not only real estate, but they're going to look at mill. They're going to look at emergent. That's what they do. That's just part of their charter. So it's not going away. And the best we can do is offer training and make sure that everybody understands and share that with your competitors. This is what we, I'm sorry, we can't have that conversation. And the reason why is because that could really put us in legal jeopardy. Me individually, my brokerage individually, the association individually. And that's why you see people, that just they aren't gonna participate, they don't wanna be a part of that, we don't want that liability for you, I don't wanna have to worry about it later on.
And the next one might be title companies. If you ever use the FAR form after like next week, it changed.
Don't go opening this Pandora's box.
Just saying, there's gonna be some changes on that FAR contract.
Well, we use a NABOR contract here usually, but on the other hand, you're welcome to use a FAR contract, you're welcome to use a FAR contract, you're welcome to use your own appropriate contract. So whatever contracts you are, make sure you understand your contracts so you can appropriately negotiate your contracts, because if you don't understand them, then you cannot assist your client. Doesn't mean you give legal advice, but like, you should understand who's paying for title insurance and, all these other pieces with respect to it. So, yeah, that's a Pandora's box, and we'll see how it gets resolved.
It's already resolved. It's in there.